at the meeting. We don't do the task force meetings. We're not required to have it recorded. And open meetings at JJ takes copious notes, so she might be able to find it. My understanding, and having, from the genesis, what's in Section A, the medical board has a little trouble with because we're not familiar with a lot of these substances and what their uses are and what their safety and efficacy might be. Plus, we read it strictly, and when you get into Section D, which is very unambiguous, if it's a controlled substance, prescription drug, also referred to as dangerous drugs, and it's injected, then it is the jurisdiction of the pharmacy board and the medical board. The medical board did not endorse everything the pharmacy board did. They were on the call. We asked why, what's your understanding, and then it was up to the medical board to produce its own list, which we did and submitted, and we have a statement that's been officially on the record. If I can pass it out, I don't know if anybody wants it, but it specifically says what happened and what its view of the world is. The real discrepancy in the Act, from what I read, and I think many lawyers might agree with it as well, is by the use of injectable. You could say that, okay, vitamins are approved in Section A, but what if these vitamins are injected and have to be prescribed? Then it obviously comes under Section B. Lidocaine, if it's topical, that was approved. But if it's injected and it needs to be prescribed, it comes under all three boards' jurisdiction. And I really do not agree that there is a real problem with reading the intent of the statute. And through going through this last legislative session, it was very clear that the legislature wanted the medical board to be involved with anything involving dangerous drugs, anything prescribed, and controlled substances, and injectables. They stuck with the language from the original.
And I'd ask Superintendent Dennis, would you like to testify? I know we've been keeping you here.
Do you want me to leave?
I'm not Superintendent Dennis, but I'll put you thoughts.
Thanks.
My name is Jim McKay, and I'm General Counsel for Regulation and Licensing. And we think that, on behalf of Regulation and Licensing, that it's premature to act on this particular part of the amendment. The reason is twofold. The first one is that to act on dangerous drugs or controlled drugs, as the medical board was testifying, has testified to earlier, when you're talking about the new drugs for injection, it shall be submitted to the Board of Pharmacy and the New Mexico Medical Board for approval. There is no such approval before this board at this time. And when you're talking about difficult, even somewhat contested drugs as to what their medicinal effect is or not, or is it, the genesis of those drugs, you want to make sure before you do act. And of course, I'm talking to medical professionals right now as well. But you know that in terms of, you have to be very careful and conscientious about such injections. At this point in time, though, we don't have any kind of approval from the medical board, and that's what's required. So in that sense, it's premature for this board to be acting on this matter at this time. So we'd have to take a step back, get some kind of approval from the medical board. Now, I understand there was presentations made by the subcommittee, and some of them were present, but again, there was no record maintained of that for the most part. But even if there was, you still would need to have an approval as to what they approve of or don't approve of before this board could act. Last, having had some experience in terms of some other regulations, that the way it works is kind of like paint by the numbers. And what I mean by that is that you can have a state statute, but the regulation can only have the authority within the context of the statute. Otherwise, it becomes the tail wagging a dog, where the regulation would have more power than the statute. You simply cannot have that as a matter of law. And that's what we believe that would be the danger and the problem at this point, to adopt a regulation that has more authority than the statute permits. So for those two reasons, we believe it's premature to act on these particular amendments as proposed right now.
And does any board members have questions of this witness? The audience members have questions of Counsel McKay? Thank you, Mr. McKay.